Yes, you're still signing in. I'm looking at numbers. Right. Right. I corrected my spelling. Just give us a few more minutes. Once you have everyone signed up, then we will start immediately after that. Okay, I think we should start in a minute. We get started now because numbers are too big, and I think we can't wait for everyone to log in. So today is a session where we're going to discuss on the role of expert witness. So it's not any witness, but an expert witness. So who is an expert witness and what are they going to say and what should they say in court? And so we're going to cover it from three different perspectives. My partners Rishi and Syafinaz are going to speak as well. Rishi is going to touch on litigation per se, in civil litigation. What do experts do? Syafinaz will cover it from medical negligence aspect. So it not only medical negligence, the element of negligence is also very wide. It includes tort, it includes nuisance, but her focus on medical negligence. And me,
recording in progress,
on the tax aspect and see how the tax part comes into play. So I guess on that note, I will start the session. It's going to be a very interactive session. We're going to spend about 10 to 15 minutes each, highlight the issues, what we want to say. Then we're going to open it up to for questions. Rishi, the floor is all yours, then followed by Syafinaz.
Thank you, Sarah. Thank you for the introduction. Hello, everyone. Thank you for taking time to be part of this webinar this afternoon. I will get straight to it, but I'll share the slide, a quick short slide that I've prepared for you all. Okay, everyone can see it. Sarah, you can see it, yeah? Can, okay. Okay, straight into it. What will I be touching on? Of course, as Sarah has mentioned, I will be giving a broad perspective insofar as expert witnesses, expert evidence in relation to civil proceedings are concerned. I will touch on a bit of the premise in which it is a exception, that being Section 45 of the Evidence Act. Move on to discuss a bit on requirements insofar as qualification is concerned, what qualifies you to be an expert in civil proceedings. And then we move on to touch on the credibility or weight to be ascribed to expert evidence. And finally, I will touch a bit on procedural aspects, as that is a somewhat dry aspect of expert evidence, but there are key pivotal information which commercial litigants, prospective parties dealing with litigation ought to be aware of. Okay, a bit about putting things into context. What is the idea of having expert evidence in civil proceedings? Well, it is simply this. A judge, despite being the sole arbiter of fact and law, which they are, despite the fact of existence of expert evidence, do lack in certain aspects when it concerns aspects of evidence or dealing with evidence, when it concerns evidence of a nature which involves technicalities, scientific evidence, so on and so forth. And when there is such a situation, the law is that the court and the judge must, and it's not a discretion, as I will be discussing in certain cases, it's not a discretion upon the judge to choose whether or not to have expert evidence put before the court as part of the issues to be determined. As to how to manage and control it, that's a separate thing, but the initial assessment would be whether or not the nature of the evidence is technical in nature. Is it something which calls for expertise outside the scope of knowledge and experience of the court and the judge? And if so, has it been done? Okay. The role of an expert witness. Now, this is something which is actually very rudimentary, fundamental, but more often than not overlooked, more often than not is governed by a very strong misconception by commercial litigants, something which I have noticed over time, and it would be naturally so. And that is this. The expert is actually an independent party, despite the fact that a private party may have appointed that person. And despite the fact that for all intents and purposes, the private party has an expectation, underlying expectation for the expert to render favorable evidence on their part. But that is not the case insofar as the court is concerned. That is not the case insofar as the role of the expert is concerned. He is, for all intents and purposes, impartial. He has to be, you know, at any point in time. If he is not, then there are rules insofar as the court is required to act by in terms of exercising caution, you know, and case law is as such. Despite the practical drawbacks in trying to achieve this, the fact of the matter remains the expert appointed has an overriding objective and overriding duty to the court. And this will go into matters of weight to be ascribed to the evidence eventually. If at all impartiality is in question, the weight is naturally going to be something which is affected, you know. So parties ought to be mindful of that from the onset, not have unrealistic, what I would term as childish expectations or short-term expectations, expecting there to be partisan commitment from experts who are coming on board. Okay, It does not advocate for one side or the other. The idea is to render the opinion based on grounds of fact, you know. So there we go, insofar as the role of the expert evidence is concerned. What is the premise of having expert evidence put before the court? Just very briefly, this is, of course, to give background to the position of the law. The position of the law generally in relation to opinion evidence is that it is not admissible. Okay, so we need to know that to start to understand why is there an exception when it comes to expert evidence. Of course, in the Evidence Act, Section 45 is your section which deals with expert evidence, and it deals with a wide range of areas, okay, but broken down into broad aspects in Section 45, foreign law, science or arts, identifying the genuineness of a person's handwriting, identifying fingerprints. And on this, science is a very, very wide area, broad area. It's not been defined by the Act, right? So it encompasses a broad aspect of things, and this has been acknowledged by our former Lord Chief Justice, Lord President Sultan Azlan Shah, in a case which says that the science is elastic enough to be treated and interpreted broadly. Okay. Common examples everyone would have heard insofar as expert evidence is concerned: civil matters, handwriting experts. Okay, transactions deal with dispute of signature, forgery, fabrication, so on and so forth. And those are common, right? But there are aspects in which it is interesting, and such few things I would touch on slightly. One is foreign law. Foreign law is the moment that the matter is out, it is concerning laws which relate to other countries. It ought to be dealt with by way of expert evidence being led by legal experts from that particular jurisdiction. And then the other point, insofar as the general rule is concerned, the court shall not decide on such matters in absence of such evidence. And here I will go straight very quickly to deal with two important cases I thought will be interesting to share today. The first case, Abda Air Freight, was to just prove the point that courts have, in situations where it is not only technical or scientific evidence per se, have still dealt with or accepted testimony of experts. And the first one, Abda Air Freight and Berhad against Sistem Penerbangan Malaysia Berhad. Mars Airlines had led two expert testimonies in relation to Indian customary laws. So our courts have been steadfast, robust in going slightly outside the scope of just merely shutting it out insofar as scientific and technical evidence is concerned. The second is the case of ASEAN Securities Paper Mills against CGU Insurance Berhad, 2007 case. What is very interesting when it comes to these two cases, the point I would like to make is this: parties, commercial litigants, have to be always mindful, together with their lawyers, of the fact that when expert evidence is dealt with wrongly, it may be dealt with wrongly at the High Court stage, at the Court of Appeal stage, but the federal court, and in two situations here in ASEAN Securities and U Television, the federal court will step in to make the record straight. They will set things right insofar as having to deal with expert evidence is concerned, how to deal with Section 45. ASEAN Securities, a bit on the facts. It had to do, ASEAN Securities was in the business of selling papers, various types of papers. They had stored their papers in a warehouse, and the papers, at some point, there was a fire and the goods were destroyed. So they had an insurance policy with CGU Insurance. They wanted to claim on the insurance. They wanted to claim somewhere around 16 million ringgit. And they put in a claim. CGU Insurance refused to entertain the claim. They said that it was a fraudulent claim. In the High Court and the Court of Appeal, ASEAN Securities was successful. Now, I just zoom in straight to the federal court and how they dealt with a situation such as this. In the federal court, they said that expert evidence of a scientific nature by 7 experts were led insofar as the propensity of certain types of papers catching fire quickly than the others, you know? And this ought to have been taken into account, for it will go towards the fact of establishing whether ASEAN Securities willfully committed arson, and having disregarded that was a fundamental error. So it is interesting to see how the federal court will actually set aside in a very strong manner, create shockwaves to going towards the root of the matter in setting things straight, insofar as expert evidence is concerned. They said it was a material miscarriage of justice, in essence, by not considering the scientific evidence, which ought to have been. Then moving on to the U Television, Sendirian Berhad, and another against Comintel, Sendirian Berhad, a recent case in the federal court as well. U Television, Sendirian Berhad is in the business of, it's a licensed broadcasting network, if I recall correctly. And then Comintel is in the business of providing solutions for hardware and software insofar as broadcasting and telecommunication industry is concerned. The dispute centered on arguably, and it was held as such eventually, technical evidence, very technical evidence, insofar as the tests commissioned for purposes of rectifying the software solution, the transmission issues, so on and so forth. I purport not to go into that. Now, at the High Court and the Court of Appeal, there was the claimant and the plaintiff was Comintel. They were successful, okay? They were successful, and there was a counterclaim by U Television that was dismissed. But in the federal court, interestingly, they step in very, very robustly, and they say the mere fact that and the High Court did this. The High Court said that the evidence which they had dealt with was technical in nature, and that is all that was required for the federal court to say. Because there is an acknowledgement that the evidence which was led is technical in nature, the court was in no position to deal with the situation without the assistance of an expert. And then they go on to hold to say, when it is held that evidence is technical in nature, it is incumbent upon the plaintiff to lead expert evidence in order to absolve, exonerate, discharge their duty insofar as the burden of proof is concerned. And it was held that because there was no expert evidence here, the burden of proof was not discharged, And then it goes on to hold, while the court had considered the technical evidence of Comintel, in essence, the evidence insofar as rendered by the CEO, rendered by the general manager, very, very simply, they said that there is no room to argue or justify to say that these evidence which were led, simply because parties may have had a technical knowledge in relation to that, is sufficient to be categorized as expert evidence, or that it was exonerated the fact that the aspect on expert evidence was dealt with as it should have been. And notwithstanding the fact they attacked everything in relation to the fact that the expert was not independent, had a vested interest, they were directly involved in the projects. So it could not be said that they satisfied Section 45 of the Evidence Act. That was a bit. So taking a step back and making assessment is very important. And over time, I have seen as a lawyer, to say, if we do not embark upon the assessment of treating then concluding at a very early stage what evidence is technical and whether there is a requirement to render expert evidence, it will be catastrophic down the line. After you have finished, perhaps, and you are successful in the High Court, you're successful in the Court of Appeal, you're already energy drained as a litigant. We all know this. And when you go to the court, or in the federal court, you're stood and staring at a fact which was so fundamental, which ought to have been dealt with in a very simplistic manner, or as long as you've dealt with it at the early stage. Okay. Requirements, it goes back to requirements insofar as Section 45 is two-pronged. It's ultimately is a fact-based assessment. It is subjective. It is to be done on a case-to-case basis. It's pursuant to the case of Junaid ibn Abdullah against public prosecutor. Does the nature of the evidence require special skill? If so, has the witness acquired the necessary skill by either academic qualification or experience so that he or she has adequate knowledge to express an opinion on the matter? Fairly self-explanatory so far as that, but there are certain salient features in assessing this. Yeah, that being, it is not necessarily the case that and in every given situation, the person who is going to render expert opinion ought to have academic qualifications per se. There are cases in which it has been held that sufficient experience, technical experience over time would qualify for a person to render expert opinion. Yeah. Now, credibility and weight is an ultimate thing insofar as expert evidence is concerned. The court is the final arbiter is what needs to be borne in mind, you know. And there, in recent case of Jasmeer Singh against Veer Singh, expert evidence is not conclusive. It is not ipso facto something which will render a finding of fact. The court is still required to make an assessment of matters in totality or in regard of evidence. It does not mean that you've crossed the finishing line the moment you have established a very favorable expert report, for example. Yeah. And there are two aspects insofar as qualification is concerned, where ultimately it will boil down to the discretion of the judge, but the discretion of the judge is not unfettered, you know, and it ought to be governed by established principles insofar as case law is concerned. One is the case of Maju Ikan, Barclays Bank, a case where the handwriting expert evidence which was tendered is an expert report, and it was unchallenged. But it did not mean that the court ought not to have taken into account the expert testimony, oral testimony of the expert given in trial. This is also important. So you have to have totality and regard to matters in entirety. And then we go on to the case of PB Malaysia, Sendirian Berhad against Samudra, which has a qualification to say that discretion insofar as dealing with unchallenged and rebutted evidence is not unfettered. You know, it ought to be dealt with caution only in so far as testimonies or reports which are indefensible. That was a particular word which was used. These are things to be mindful of. Okay, finally, I just want to touch a bit on, I want to just touch a bit on procedural aspects. You see, there are various procedural aspects, but this is something actually which ought to be in the hands of lawyers. But over time, I've dealt with, and I realized this again, fundamental things are not observed, and it ends up in catastrophic consequences insofar as litigants are concerned. And what is that? Of course, when it comes to dealing with experts, there are two types of experts to be appointed, not to say two types, two provisions. One is the court can appoint an expert in their own volition, and this is provisions to do with what is known as an amicus curiae, which is a friend of the court, which is supposed to come and assist the court, a person who is independent for all intents and purposes. For practical purposes, for more often than not day-to-day commercial litigation, civil litigation, it is got to do with your Order 40A Rule 1. For the Order 40A Rule 1 has got various facets to it. One very important thing which is overlooked, I suppose, out of inadvertence, and I'm not going to ascribe it to any particular party, although it's rather obvious who, is that expert evidence is no longer something which you tender by way of a report in your common bundle of documents. If those who have experience in having court matters, they just have sometimes a situation where your lawyer would tender it by way of a document by way of the common bundle of documents. What will happen then is that a technical objection will be raised. You ought to do it by way of exhibiting. The expert must exhibit their report through a affidavit signed, both report being signed and the affidavit signed and then filed in court. After that, the procedure is that if there is any issue in relation to that, a list of questions can be put by the opposing party. And then if there are conflicting evidence insofar as parties are concerned, if the other side has evidence which was tendered, expert evidence, which of course naturally there will be a clash. What the parties are supposed to do then is that they either sit together to come to a common consensus, to identify areas, to narrow down issues insofar as the expert evidence is concerned, or they go on to cross-examine whatever issues which remain as issues. Okay, so these are management of the manner and sequence in which evidence is led, and then finally the overriding duty to court is very important, because naturally the issue will always be both parties tendering evidence through experts which are favorable for themselves, but the court will have to play a role and assess at that point if it is coming across both expert report and oral testimony of the expert coming across as partisan. It would have to be highlighted to them by way of a caution. And this was done in that Singapore case in GSI shipping. All I have for today, Sarah. Then over to you, Syafinaz.
Thanks, Rishi. Let me just share screen. Hi, everyone. Okay, Rishi has gone through the litigation part. I will focus into the area of medical negligence. So as we all know, expert evidence is definitely I would say, the main evidence in a medical negligence litigation, because, well, you need the doctors to tell whether it's negligent or not in respect of the standard of care. More so, the evidence in medical negligence cases, as we all know, is very technical, complicated, and the court would most of the time require the assistance of expert witness, doctors, medical professionals. Right. Okay. Usually, I mean, it's common, like the plaintiff and the defendant, the plaintiff will bring their own expert, the other side will bring their expert, the doctors on their side. Definitely opposing views, for sure. So how does the main issue in the medical negligence litigation is, how does the court then decide, whether the doctor, the defendant doctor, or the medical professional in question actually perform below the standard of care? So basically, the court is listening to one side, saying, no, this is the approach you should take. The other side is saying, no, this is the correct approach. So how do the judge doctors? I will go through the test to determine the standard of care. It has moved. I can't say it's settled in the case of Dr. Hari Krishnan, but let us just start from to see how the test has evolved. Okay, first, the Boehm's test, I think we all are aware of this, is essentially doctor knows best. So the court must accept the view of the expert in the medical field, in the particular discipline, let's say gynecology or something of that sort. Right. So basically, in this case, with this test, we are saying as long as if there are two conflicting views, and the defendant doctor actually adopted one of the views, so you can't say he is negligent. Either one, he followed one and he definitely didn't follow the other, he's not negligent. So basically, the standard of care in Boehm's test is decided by the medical profession. Stop, that's it. We then move on to, I call it the qualified Boehm's test, because the English courts in Bolito actually qualified Boehm's test in the sense that, yes, doctor knows best, but the expert opinion given by the doctor, the medical professional, it must be able to stand an analysis, a logical analysis. Merely because Dr. A says this is what you should do, Dr. B says no, this is what you should do, and the defendant doctor does one of it, opted to do one of it during that procedure, he cannot be said to be not negligent. He cannot be said to have actually reached the standard of care. So the court must actually, I would say, the judge has a bearing to decide. He has to decide whether the defendant doctor's approach actually can withstand logical analysis. Basically that. So it gives the court a bit of a I wouldn't say a bit, it gives the court a duty to actually look into the logical approach taken by the defendant. Right. Then after, we have been following the qualified volumes test in Malaysia most of the time until the case of Fu Fiona, where the court actually considered the test propounded in the case of Rogers and Whittaker's test, brilliant case. They took the position in that case. In Rogers' case, the duty is placed on the court as the real judge, the real arbiter, to determine if the standard of care has been breached. The duty should not be delegated to a medical expert. So it's basically the court who decides. With, of course, the expert evidence given. Sorry, just okay. Oh, like I said, the case of Fu Fiona applying the Rogers test brought a bit of an uncertainty to the medical negligence litigation area in Malaysia. This brought the case of Dr. Hari Krishnan into picture. This is a case, I guess, is known to many. In this case, the question is whether the qualified Olam's test or the Rogers and Whittaker's test should be the test adopted in order to determine if a standard of care has been breached. That was the question, whether the test in the qualified Olam test or the Rogers and Whittaker's test should be the test applicable. That's essentially the question. So in Hari Krishnan's case, the court actually said that the court actually drew a distinction between two sectors of it. First, diagnosis and treatment in medicine. Secondly, duty to advise the patient of risk. The first part, diagnosis and treatment in medicine, the court held that this is not within the expertise of the court and therefore cannot be resolved by the court, and hence we are applying the qualified Olam's test, which means the expert gives evidence. Let's say most of the time it's definitely two conflicting evidence. The court will have to actually run a logical analysis and then come to a conclusion as to whether the doctor or medical professional in question actually breached the standard of care. Right. So in this regard, the qualified Olam test applies. With regard to the duty to advise patient of risk, this is an issue of fact, according to the federal court, that the courts are able to determine. Thus, we're going towards Rogers' test, where the court decides. Right? So basically, when we are looking at the diagnosis and treatment in medicine, I would say that the reliance on expert opinion is more than where we are talking about duty to advise the risk. Reliance is there, but the weight is more for the first category earlier. And therefore, when we are having expert opinion, whether you're on the plaintiff side, whether you're on the defendant side, the main issue we have to see here, we have to keep in mind is that the opinion given must be capable of withstanding logical analysis. Very important. So, like I said earlier, doctors know best, but the expert opinion must be logical, must be justified. Otherwise, the court might just fall, it's not reasonable, it's not logical, it's not, and the court will just reject it. The court will not admit it. So then our issue here is, so what do we do when we are calling an expert doctor, an expert opinion? We're calling an expert, and the doctor is coming in to give evidence. The main thing here is, with the fact that it's no more a question of whether expert A says this, expert B says this, I do one of it, I'm all right. It's no more that. A doctor who is called as an expert, he must be very, very familiar and well-versed in the medical field in question. Let's say a surgery to remove, ovarian removal surgery, operectomy, partial ovarian, or something of that sort. You must bring a doctor who is an expert in that field. If you bring a general opinion, the court might not be able to say, it might not be able to actually go through that logical analysis part we mentioned earlier. So the doctor, firstly, must be very, very well versed with that area. Secondly, he must also be aware of the medical standards required. Here, probably, okay, not medical standards per se, yes, well, medical standards, but the duty he has to the court. We must explain to him that, look, the depth of the explanation the court requires is not just, surface, because the court will actually run through its own analysis to see not to say its own analysis, the court will weigh the evidence and see which one succeeds the logical analysis part, right? Okay, we have heard many times in a medical negligence claim, if someone is acting for the plaintiff, it's very, very difficult to get a doctor to testify for the plaintiff. That's common. So here, and even if you get a doctor to testify for the plaintiff, it's usually from overseas, from my previous experience, because very rare someone wants to testify against your own colleague in your peers in the profession. So here, the doctors they should not protect their peers in the profession. They should be fair. They should act impartial. You're not putting your peers into trouble, but you're testifying as to whether what this medical professional did in that particular area of medical practice, actually conforms with the standard of care expected. So you have to be impartial. You're doing a duty to the court. Your duty is to the court. You cannot incline on one side. For as long as you are testifying, you must justify what you are testifying. All right. So basically, concluding this, when you're having an expert opinion, you're having a medical professional coming in to give evidence, I would say the most important factor is, the first one I would put, you must be impartial. Because when you are impartial, you will be able to give evidence, the best evidence as to what's the best practice. Leaning on one side or another might not be good, because you will not be able to give a good justification, and then if you can't withstand the logical analysis. But right, I'm being very brief here. If you have any questions, I'll answer that in the Q&A session. Sarah, over to you.
Thank you, Syafinaz. Now I'm going to go straight dwell into from a tax aspect, because as you know, in tax we also bring in witnesses. And let me get my screen. Oh, Afika, you are not allowing me to share screen.
Okay, hold on, sir.
Please.
Done, sir.
Okay, thank you. Okay, so there we are. So I'm going to start my session by looking from a tax case that I went to court, a real case that Dr. Naber and I handled, the case. And you can see the issue was transfer pricing in this case. Transfer pricing is a key area where you need to have an expert witness most of the time. In fact, in all the TP cases that we do, we bring an expert witness to testify. Very recently, I did a stamp duty case, which we won, and we brought in two land experts, valuers to testify, but no grounds yet. So I can't discuss much on that. But just to share with you the issues here, it's all about commission payment and business process improvement, the two TP issues here. And you will see the witnesses called. We called 7 witnesses to court. We called the finance GM. We called the managing director of another shipping company. Expert number 3, witness number 3, AW3 is a head of transfer pricing. Yeah. G means group head of transfer pricing of the Danish company. Then, of course, number 4 is a gentleman from Denmark as well on the operations side. 5 is a former employee who became a consultant. 6 is assistant manager. Number 7 is an expert witness. Yeah, he is from a partner of KPMG in this case. So you can see from the case stated, the aspects where the judge looked at the witnesses' evidence. You can see AW3, the Danish expert, explained that he used pan-Asian comparables to do his TP study because he said they are being a multinational, they got to use pan-global, pan-Asia comparables. Of course, for those who are familiar with the tax regime will know Malaysian IRB only wants local comparables. But here the client explained why he used pan-Asian comparables. And he also further explained that the court found that the evidence paid of 1% is at arm's length, because you look at TP report prepared by AW3 and AW7. Yeah, so it's very clear how the evidence prepared by the expert witness was testified, how they arrived at the comparables, and they spoke about the margin. Yeah, and I want to show AW3 and 7, the two experts explained why they chose the particular methodology for transfer pricing. They explained to the exhibit, which was a report, what they have done. Again, AW3 explained and concluded. What I wanted to do is, you must see that the AW3 testified the IRB's decision is not correct. He explained that he has come across many transfer pricing audits in his lifetime. But however, in such cases, the tax administrators were never difficult on agents, and these were all on companies that was making no profit or low profit. In Malaysia, the Malaysian entity was making a margin of 18.92%, which was higher than the market industry average. Yet the IRB did a TP without any good reasons, and he said this is very troubling because in other jurisdictions, even with a lower margin, the agents were not subjected to any transfer pricing adjustments. So he's an expert giving his assessment on what is happening, and he said, this is very interesting, yeah? Having a TP expert for more than 15 years, and this is the world's largest shipping company, dealing in 100 over countries in the world, and he said, dealing with the Malaysian IRB was the worst experience. Yeah, this is an interesting case because recorded in the judgment that the witness said dealing with the Malaysian IRB was the worst experience he has gone through in his life when it comes to TP. And the court commented that the evidence of the experts, among others, were critical piece of evidence in this case. And of course, RW1 is the IRB's witness who testified and all got beaten up in their evidence. You will see in one case, judge said the revenue witness flustered during the cross-examination. I believe that we cross-examined her in court for 8 days on this case, yeah? So she got beaten up on all those things, and then she agreed. But you see how the judge said, after comparing her evidence, the judge said that AW1, 3, and 7 testified very clearly, and these witnesses' critical evidence was not cross-examined by the IRB. So the IRB had didn't even put the case to them. So our expert witness was so strong that their evidence couldn't be challenged by the IRB in court, yeah? And then the court said in their evidence, they said very clear, you see, we express our view in terms of trial strategy in the absence of a countervailing TP report somehow prepared by respondent, if done, would have afforded them and the revenue their own countervailing document and counterattack. But in the absence of such, no wonder RW1 appeared flustered and meek in the face of intense cross-examination by the appellant's counsel with exhibits B5 and B6, and soon enough, RB agreed, yeah, that she agreed with the evidence led by us were correct, yeah. And we put this verbatim. AW3 expert witness was asked this question, you know, I attended the meeting, look at the report, did you try to agree on the rationale? She said no, yeah. When you were asked about the meeting, did you explain? She said no. So very clear based on the two experts, the IRB's witness and our professional expert. The court said there was no explanation she gave, and whatever she did contradicted AW3. And when there's a contradiction, they said we find AW3 to be more probable because of exhibit that we had. So very, very clear. AW3, the expert witness from Denmark, was able to stand by his report. And when it was put to him, he was able to defend himself against the IRB. So, and the judge said, there's no point, they think, that AW3 came all the way from Denmark, just to come and have a meeting with IRB. The T is missing in the meeting here, yeah. Came to just to see IRB and just to listen to the IRB. So we create very clear. And the judge said RW1's answer by comparison is not probable, to say the least. The judge is being very polite to say that she's lying, And based all the evidence, the court ruled in our favor on the TP issues, yeah. And you can see again, all the evidence we have evaluated, we did all these cases, so clear. All the witnesses that we put forward in this case were not materially challenged in this case, yeah. So what I wanted to share from a tax position is this, my friends. There is value when you bring in an expert in the right cases, especially in a technical case, and especially when it comes to your tax treatment, where you say a particular expense is capital or deductible, or a particular income is capital. That expert witness plays a role. And another reason why an expert witness help is because an expert witness is someone who will be independent when they give evidence in court. If you call the CFO, if you call the general manager, they all are there to tell the truth. But the very clearly, whatever you say is essentially what you call whatever you say is going to be, there may be some issues they may raise. They may say that, whatever you say, you can be prejudiced because these are your employer, So that is where I think we need to be careful. As much as we have our own witness to tell our position, but we must also try to always get an expert to collaborate and support the evidence that we put forward. So this is what I wanted to cover from a tax perspective, but I see many questions already being posted. I guess it's best perhaps I dwell straight into the questions now, because we want to make it very interactive, and listening to myself is not so easy, I'm sure Rishi and Syafinaz share the same as well. Webinars are far more painful than a physical seminar, because you can't see the audience, you can't see, and you can't see whether you're following you or whether you're excited. I stopped cracking jokes, I used to give seminars in the past, half of it were jokes. But now you can't, because you joke also, you don't know whether you're laughing or not, So let me start. And there's some questions Rishi has asked to answer. Of course, some questions, Syafinaz, please indicate which one you like to answer. And I asked, and when Syafinaz, you want to add on to Rishi's view, feel free to jump in, yeah? Now,
Yes,
and maybe Rishi, Syafinaz, we can choose our questions as we go along as well, So I start with the first question by Prakash. When there are two different experts, two differing and conflicting testimonies, the judge has a right to choose. But my question here is, do you agree that the judge can also do his research in coming to a reasoned conclusion without relying on these experts? Okay, so is the judge entitled to choose evidence of one expert over another? Prakash, I must tell to you, if the both experts are your own experts and they contradict themselves, your case is gone, okay? So that is my first response to you. Make sure your own witnesses do not contradict themselves. Your case will be burnt, right? I assume when you say two different experts, that means your expert and your opponent's expert. Of course, there will be contradictions. And in that case, who can the judge choose? And what would the judge decide in choosing? Rishi, can I ask you to start to say your views? And Syafinaz, maybe your input, especially in a medical fraternity, you will have two different doctors saying two different things. Thank you.
Okay, Prakash, insofar as commercial matters that I have handled, generally the judge prefers one conflicting or expert opinion over the other. And he would then give reasons as to why he prefers that expert report. But to answer your question specifically, can a judge conduct an independent assessment on his own? He can. He can. And he will have to then come up with reasons to depart from the expert opinions which are given before the court. Now, in so saying, in so doing as well, the judge must be mindful of the fact that this can easily be open to attack at the appellate stage, that the judge went on a frolic of his own, so on and so forth, and the judge misdirected himself for whatever reasons because of not taking into account the opinion of experts in the field, So unless there are grave factors, flagrant issues, if you ask me, the judge ought to, as far as practicable, try and rely on what is before him, simply because it is also to be borne in mind that we are a adversarial system. We're not an inquisitorial system. So as an adversarial system, when private parties are presenting their dispute, it is left to them. The judge ought to go with that. Unless, of course, it is just, it flies off the face of the principles of logic, the principles of law, then yes, the judge has a latitude. They have the discretion to depart, and I have had such on occasion. I have observed, I was not in that case, but a particular Oxbridge judge has got a tendency to set the record straight insofar as parties are concerned, trying to tell them, and I can understand his inclination towards having to conduct his own research, on various instances, simply because what is presented to the court is unreasonable. It cannot be accepted. That's all I have to say. Prakash, Syafinaz, do you want to add anything?
Yeah, thanks, Rishi. Zooming into the area of medical negligence, I think for you to get one expert evidence if you're on the plaintiff side, for you to even get one is already difficult. So yeah, like Sarah said, you have the risk of having two conflicting expert evidence if you have. So, coming on, you have one expert evidence. So you're saying whether the judge can also do his own research to come to a reasoned conclusion without relying on these two experts. Yes, I'm going to answer in regard to medical negligence, right? The judge, if you're going through that Bolito's test, I would say the judge is not exactly doing his own research to come to a reasoned conclusion, because these are areas which are very technical and complicated. The judge is weighing between evidence A and evidence B and looking at the circumstances of that case, whether the standard of care has been breached. So I think I agree with Rishi. The burden should not be placed on the judge, or we cannot move it to the judge to do his own research to come to a reasoned conclusion on the two experts. It's merely assisting the courts. And in my view, the court would see the circumstance of that particular case specific to that, and whether A or B should be accepted in the realms of medical negligence. Yeah, that's all, Rishi. Sarah?
Syafinaz has a question, but Divagar, his question is, which is the decisive case today when it comes to the test for standard of care for diagnosis and treatment? Is it Bolan or Bolito?
For diagnosis and treatment, thanks, Sarah. For diagnosis and treatment, in the case of Hari Krishnan, the court has said is the test in Bolan as qualified in Bolito. That's what the federal court said. Therefore, the test is what I call the qualified Bolan's test.
Right.
So, yes. So, merely the court, like I said, will actually go, the expert opinion will go to a logical analysis. So which one the court will actually take on, rely on later, depends on the logical analysis, thereafter.
Syafinaz, there is also the Australian case of Rogers.
Correct.
Right. And is that also become law in this country?
Law in this country, if you're looking at the case of Hari Krishnan, I'm relying a lot on this case because this is like the case that actually settles the law as to the standard of care. Like I said earlier, there are two parts here. First, duty to diagnosis and treatment. Second, duty to advise risk. Your question, Sarah, yes, for the second part, duty to advise risk, it's Rogers and Whittaker's as what the federal court has propounded in that case. Yeah. So for that part, Rogers and Whittaker's apply. The Rogers test apply. Duty to advise risk.
Thank you. If you're wondering why I'm wearing a mask, I need to sign something. So yeah, there is a question here. I want to post to Rishi, but it's in the chat box. But I take it because from a strategic view, would it be wise to call a witness as an expert witness when the witness in his report is unable to come up with a firm and conclusive view? Is there any use to produce such a report or witness in court?
Thank you, Sarah. Thank you. I see there is from T. Chia. Where to answer your question very simply, no. You see, it is a tendency insofar as civil proceedings are concerned. Experts are very reserved. Sometimes they want to qualify it to a point where whatever is rendered as testimony is neither here nor there. All that turns upon that is this. There will be no weight ascribed to the testimony if it is neither here nor there. It has not helped anyone, let alone the court, which is the most important person who has to have assistance from an expert testimony. Conflicting or not, it doesn't matter, but there must be value of the expert testimony rendered to the court for purposes of assisting the court to make the determination. Ultimately, the end goal is all simple. It's fundamental. What is the purpose of rendering expert evidence? It's not to strengthen a particular party's case. If it is something which is achieved in the cause of it, well and good. But that's why the rules are there to say what is the overriding objective of the expert. It is to assist the court, the judge. That is why the judge has that much of latitude, that much of discretion. Now, of course, we have checks and balance insofar as the provisions in relation to expert evidence is concerned. Going back, strategic point of view, definitely no. If you ask me as a lawyer, I will in fact borderline on a very strong basis insist that no such testimony be put before the court because it will create impressional issues. What is the purpose of you doing this except for wasting time and cost? And certain judges are very mindful of the fact that you wasted the time and cost of the court. That's all, Sarah.
Rishi, the next question. Is it mandatory for an expert witness to prepare a report in addition to oral testimony? Syafinaz?
Yes, Sarah. Thank you. I think Rishi has highlighted this. Yes, under Order 40. Correct, Rishi? 40, right?
40A.
40A.
If it's private party, yeah.
Right. So yeah, you have to prepare a report in addition for in addition to giving what you call it again, oral testimony in court. Yes.
Thank you, Syafinaz. My next question. This is a question that that has been asked here, and I think all three of us will answer this. The question is, speakers, based on your experience, how do you attack expert evidence of the other party? Since it often involves technicality, does that mean that one party brings in expert, the other party must always bring in theirs too to counteract? I will let Rishi to answer the second part. Must you bring an expert to counter what they say? In a recent stamp duty case I did, the issue was an evaluation of the land. The land was next to a Chinese cemetery. Okay, at the back was a Catholic cemetery and an abandoned shopping mall, which an eyesore, and there is a low-cost housing apartment. My clients bought the land for 54 million ringgit. They thought it's a bargain for them to build some condominiums and sell, despite the location. The land office, the stamp office took the view that the land is actually worth 100+ million ringgit. Okay. Of course, I'd have the mind to ask their officer to buy the land for 100+ million ringgit, but they won't have that kind of money, isn't it? So because you come and say the value is 100+ million ringgit. And what we then did was, when the report was prepared by the officer, without him telling court that the shopping mall is an abandoned shopping mall. Yeah. He wrote there's a shopping mall, but he didn't say it's an abandoned shopping mall. So when I cornered him, and lucky my expert said it's an abandoned mall now. I showed it to him and I said, "Are you sure this mall? Yeah, is it operation? Yeah, it's operation." Later, when I asked him, yeah, but it's been abandoned for 2 years. He said yes. So the time he prepared the report, he knew it's an abandoned mall, and yet in his report he didn't disclose that. That is some element of being, dishonest there, being economical with the truth, right? Number two, I asked him, "You agree with me that Malaysia is made of multiple races, that generally the Chinese are averse to buying plot next to a cemetery or a funeral parlor?" He said, no, not at all. It shouldn't be a factor. So I made it very clear to him, it's the Chinese who are averse. I didn't know the witness was non-Chinese. Little did he know, the Supreme Court made a comment on this many, many years ago, that Asians don't like to buy property next to a funeral home or a cemetery. So I just kept quiet because I know he was lying. We have so many people listening to this conversation today, to our chat today. Please tell me, how many of you all have your home next to a funeral parlor or next to a cemetery? Can you please tell me? Hardly. Your wife would have left you long ago and said, "What's wrong with you?" Nobody buys a home next to a funeral parlor. There's a banker in front of me and he's also laughing too. At least I know someone is laughing at what I'm saying now, But you see, but the witness said, no, irrelevant. But when I showed it in submission to court, the judge took note that even the Supreme Court has noted that when your property is next to a funeral parlor, your property, your value will depreciate in a large way, So very, very important to note how this kind of behavior of the witness. So you need to put it to them to show that if they're dishonest, very good. If you're talking nonsense, even better for you. So that is my experience how I attack the witness. I spent a day and a half with him in court, my cross-examination. The judge was saying, "Mr. Saravanan, you're repeating. Mr. Saravanan, can you hurry up? Mr. Saravanan, can you wrap up?" I said, "Judge, one more point. I just went." For the whole day, I let him say what he wanted to say. Next day, I went on the attack. And you know what he eventually said in court? "Ini bukan keterangan saya. Ini bukan report saya yang Arif. Ini report siapa? Ini report value lain. Saya hanya hari ini datang memberi keterangan saja." So here's the evidence lah. Essentially, he's already admitted in court, not his report, he's just reading out the report. And I nailed it in my submission. It is hearsay evidence. His evidence cannot be accepted by court. And in ruling in our favor, one of the reasons the judge gave was hearsay evidence. So this is how I think you need to trap the witness and beat him up when you get a chance. When I say beat him up, when he exposes himself to all this. Rishi and Syafinaz, your thoughts?
Thank you, Sarah. Building on what Sarah says, to answer your question, must you bring an expert to counter it? Not necessarily, not always. It will depend on a case-to-case basis. All of that is there because larger considerations involved are cost, the underlying cost factor. You have to take that into account. So echoing on what Sarah says, if you look at it on the face of it, if the person is lying, if the person is giving evidence which has got no probative value, then undertake a rigorous cross-examination exercise. There are more often than not situations in which who comes to court is trying to pull off or pass off as an expert. So the assessment insofar as testimony is concerned is crucial. I have had on occasion to deal with a situation where my individual assessment was someone was trying to pass off as a pseudo expert, a half expert. This is an issue as well. So what is a pseudo expert? Okay, because it is something technical to you, you do not have the sufficient expertise to be able to unearth that. I suppose that will go into questions of whether your lawyer or you are able to do it on a lesser basis by getting someone who has the knowledge to be able to unearth it by the form of questions, to ask cross-examination questions, and then keep it to your lawyers asking those questions. If that is the ultimate issue, cost is an issue, So not necessarily always. And in this case of the pseudo expert that I had to deal with, It had to do with a lengthy trial. It had to do with opinion in relation to racetracks. It was fairly technical, but when it was highlighted to us, where the fundamental issues were lacking, and when rigorous cross-examination was undertaken for 2 or 3 days in relation to that, what we eventually got that person to admit was that he was not a racetrack expert, but just merely a landscaping artist insofar as racetracks are concerned. So there we go. There are ways in which you can tackle this, not always having to consider an engagement of an expert, because we all know sometimes how that may cost an arm and a leg. That is all, Sarah. Syafinaz?
Rishi, I agree with what Rishi said. Just one point to add. I can't recall the case offhand, but there is a case that involves, I think it's architect's report or something. I can't recall whether it's architect or quantity surveyor. In that case, the court actually held that since the other party did not have an architect's report to actually contradict what this architect said in relation to the building defects, therefore, it's taken that this report is admissible and so probably in that kind of situation, I really cannot remember the case offhand, but like what we say, it depends on a case-to-case basis. In certain cases, yes, you need to have something to contradict what the other experts say. Yeah.
Thank you, Syafinaz. One question. Good afternoon, Mr. Sarah. What are the qualities to look for in selecting an expert witness? Number one, he must be an expert. Yeah. Number one, he must be an expert. Number two, he must be well qualified. Please check his degree. You know how Malaysia is now, everyone got degree and doctorate and all this Mickey Mouse degrees. So please make sure it's a proper degree, not a degree from a university that it doesn't exist. Okay. And if there's an MBA, please check whether it's a real MBA, whether it's a post MBA or not. Yeah. During COVID, many of us got all kinds of qualification, online qualification. Then number three, look at his journals, whether he has written articles, whether he has run, written reports. Okay. Then next is to see whether he has testified in court before or not. I think these are the factors you must consider. I was an expert witness recently, last year in Singapore, the Singapore High Court on a tax matter. And I testified on Malaysian taxes. And fortunately, if you want the matter, my clients won and my evidence was accepted by the judge. So qualification is very, very important, that I think starting with that. And as a witness, you must tell the truth. You are not there to cite one side. You are there to assist court by telling the truth because you're the expert. That is what I think the view. Rishi and Syafinaz, you share the same thoughts as well? Yeah.
Yes, certainly.
Yes.
It's just one aspect. There has been an instance in which I wish to relay and share. Of course, I feel that was an exception to the general rule. The chap insofar who came to the expert who came to render evidence insofar as the handwriting aspect was concerned, did not possess anything beyond an SPM certificate. He did not possess anything beyond an SPM certificate, but he is a regular house name insofar as handwriting, fingerprint evidence is concerned. And it was in the PJ Sessions Court. And to me, demeanor, disposition, and professionalism-wise, he came across, and until today, I felt that he was the better expert amongst every other expert I have seen in court, but that is an exception. And the law allows for this, insofar as sufficient experience is concerned to then serve as weighted probative value insofar as the expert evidence is concerned. That's all, Sarah. Sarah, you're muted.
If the expert witness has raised an issue which has not been addressed by the plaintiff's expert, can the plaintiff recall the expert to address or negate that specific issue? Syafinaz?
Thanks, Sarah. I think expert reports, it would have been exchanged earlier, right? I mean, under Order 40A, it has to be filed in court earlier. And actually, I have not come across this situation, but whether you can refile, sorry, what was the question? Recall the witness. Well, if such circumstances happen to you, perhaps you can actually ask the judge since, but you see, it boils down to the question whether, are you aware of that report earlier? I mean, was the report given, or it was just thrown at you at the trial? It can't be, right? It would have been given earlier.
Yeah.
So if you have not addressed it, I don't think you would be able to recall the expert witness, no, unless it's thrown to you at the trial, which I think the judge wouldn't even allow the opinion to be in the first place. So yeah, simple answers to that, I don't think you can recall.
Yeah. Otherwise, adversary litigation won't work, isn't it?
Yes,
Yeah,
keep
that's
on
the idea
recalling.
of adversary litigation. So make sure that, as counsel, you got this duty to make sure you're very thorough, that your witness says whatever you want to put in your case. You see, there is no turning back there. There's no second chance, because the judge cannot just let you, submit. And so remember that. Then.
Sarah, I just wish to share on that point. Absolutely right. Everyone says, because it's all in line with Order 34, the new PTCM rules, how judges would view these things in a very strict manner, right? But I've had a situation, in an exceptional situation, you have to argue interest of justice. You have to argue interest of justice and explain why these are things which have arisen as a matter of surprise, or you're taken for whatever reasons. You're definitely going to try and argue or make the case that it is an ambush, right, insofar as civil proceedings is concerned. And in that exceptional situation, the judge had allowed for the recall of witness.
There is a question here whether the lack of qualifications of an expert affects the weight or admissibility of the evidence. If he's not qualified, he can't be an expert. We can't call our grandmothers to come and testify on medical issues, because if you go and ask our grandmothers, quite a bit of medicine, I'm sure it works, but that won't make them an expert. So we must be careful who we want to call. There's another question. What kind of witness would you need to call to prove that oil palm is a fruit? This is an ongoing tax case. Which kind of expert? So you need to bring in a botanist, I guess, who specializes in oil palm studies. And there are institutions in the world, in England, London School of Tropical Science and specialist institutions in England, where they only study oil palm and all that. Those would be the experts that you want to call to come and testify. I got a case where I'm in the midst of engaging an expert on electricity to testify. He's just an expert on electricity to testify on a tax matter. So they are specialists to go on court, but they must be the experts in the field, and otherwise you can't call them expert. Remember, we are talking about expert witnesses. Now, finally, will the character or reputation of an expert witness affect his credibility? Now, of course, if he has many girlfriends, that shouldn't affect the doctor's testimony in court. But you know how it works in real life. Judges are human beings. Everyone is a human being. There could be prejudices. Now, if the expert is able to withstand, assuming there's some slight questions or some slight remarks made about his past or his character, he cannot get offended. You must stay cool to it and say, yeah, so what? I'm here to answer on this. You don't get angry. You stay cool and you just answer. Then you're all right. But in that, coming on slighting witnesses, and I make this the last question for us, you must get an expert who is composed, not animated, who cannot get angry so easily. You are the experts. Don't talk so much. In the tax case where I testified, there was another tax expert to testify, another lawyer, and the judge had to reprimand him each time because he was concluding the matter. So the judge said, I am the judge. I do the conclusion. You do not conclude. Please just answer the question. Don't conclude. The question here was whether our clients in this case evaded tax. So I gave my view. There was no evasion based on this. Whilst the other side said, while the other side witness concluded that he is a witness. So very, very clear, Okay. Rishi and Syafinaz, any parting comments before we end it? It's already 3:45.
No, sir. Thank you everyone for attending the webinar today. Looking forward to the next.
Thank you, everyone.
Syafinaz?
Thanks everyone for joining us today. Join us again for our next one soon. Sarah?
Yep. Thank you very much, friends. Take care and stay safe and get yourself vaccinated soon. Yeah. Okay, I'm getting some remarks that you all are laughing at my jokes. Thank you very much. Okay. Take care then. Bye-bye.
Bye.